and C. In relation to GR number 213181, Francis H. Hidalesa versus Chief Justice Maria Lourdes P.A. Sereno et al., only on the merits of her separate concurring opinion, but not on the deliberations of the court in this case.
Okay, so since our resource persons do not have prepared opening remarks and or affidavits, perhaps before we proceed, we would ask them to, and I direct the COMSEC to please administer the oath for the two resource persons. Please stand up, Justice. And Attorney Marquez, please.
Please raise your right hand and state your name for the record.
I am Justice Teresita Leonardo de Castro.
I am Jose Moedas Marquez.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, I do.
Thank you. You may take your seat.
Yes, I do.
Thank you. You may take your seat.
So, if you want to add to what you said earlier, Madam Justice, we will now give you the floor.
I'm ready to answer
Just
questions
answer.
from the committee, but I wish to ask permission to refer to my documents in the course of my testimony. Because, you know, the incidents involved in this proceeding happened many years ago. The earliest was in 2012. And at that time, it was beyond anyone's imagination that this hearing will come about. So, I would like to seek that permission
Please,
to refresh my memory in the course of my testimony.
please, you may use all your references to be able to refresh your memory, and likewise, Attorney Marquez. So the table is now open for clarificatory questions. You have a copy of the complaint, the answer, the reply, and the rejoinder of the parties in this case, and you have the copies of the administrative matters that are related to those matters that our resource persons will testify on. So I guess we will be ready on these matters. And so we would like, again, may I ask everyone, for those who would like to ask clarificatory questions from our resource persons, please register your name with the COMSEC. And we now recognize the Honorable Majority Leader Fariñas for the initial clarificatory questions.
Thank you, Mr. Chair. Good morning, Your Honors. Good morning, Madam Justice.
Good morning.
Justice Marquez, good morning po.
Morning.
First of all, ma'am, on behalf of the Speaker and the House of Representatives, I wish to thank you for accepting our invitation, for honoring our invitation, and kindly relay to the Supreme Court the appreciation of the House for upholding the power and duty of the House in impeachment proceedings. Maraming salamat po, ma'am. This is unprecedented, I think, that a member of the Supreme Court will appear and has been authorized by no less than the Supreme Court to appear before the House of Representatives. Ma'am, you are a very intelligent person, being a justice of the Supreme Court. We will not be asking you questions, but kindly educate us and inform us about the matter regarding the issues involved here. First, I'll concentrate on the alleged illegal creation of the Regional Court Administration Office Number 7. And we have in our possession, ma'am, a letter containing 3 pages purportedly coming from the chambers of Teresita J. Leonardo de Castro, Associate Justice. It's dated December 3, 2012. may I ask the page to kindly give a copy to Justice Castro for her to identify this one. Oh, ito na. This is an extra copy of what I have. Tingnan ko lang, baka naman magkaiba. Yun. Kindly show the good justice. There's a signature, ma'am, on the last page, which legibly shows Teresita Leonardo de Castro.
Yes, this is my signature.
And this was your letter, ma'am.
Yes, this is my letter.
It is a memorandum, I'll read into the records, memorandum for Chief Justice Maria Lourdes P.A. Sereno and the Associate Justices from Justice Teresita J. Leonardo de Castro, recall amendment of the resolution dated November 27, 2012, issued by the Chief Justice in order to conform to the deliberation of the Court en banc and the said date in administrative matter number 12-11-9-SC, and it's dated December 3, 2012. This is very relevant to our proceedings, ma'am, because one of the allegations of the complaint is that on paragraph 4.1.1, it states here that respondent Sereno and 4.1 committed a culpable violation of the Constitution when she falsified the resolution of the Supreme Court in AM-number 12-11-9 SC. And in the succeeding paragraph, it states, ma'am, upon her assumption to office as Chief Justice, Respondent Sereno unilaterally issued Administrative Order number 175-2012, open parenthesis, designating the head for the Judiciary Decentralized Office, another bracket, JDO, close bracket, in the 7th Judicial Region, close parenthesis, dated November 9, 2012, reviving the Regional Court Administration Office in Region 7, which she termed JDO 7 without the knowledge of the Court en banc. And then the next paragraph, Attorney Gadon alleges that to ratify her unilateral act, she made it appear that the Supreme Court en banc subsequently issued a resolution approving the revival of the Arcao 7, a project that was supported and funded by the Asian Development Bank, but scrapped by the Supreme Court following a failed pilot testing in 2008. The resolution, which was supposedly issued on November 27, 2012, in AM number 12-11-9-SC, reopening the Regional Court Administrative Office in Region 7 Ridge. This purported resolution contains the following matters. Open parenthesis, open quotation marks rather. The court resolved to A, ratify the action of the Chief Justice Maria Lourdes P.A. Sereno to revive the Arcao in Region 7 with Phase 1 on A, procurement, B, approval of leave, C, payroll administration, and letter B, appoint Judge Geraldine Faith A. Ekong, Deputy Clerk of Court and Judicial Reform Program Administrator, as officer in charge of Arcao 7. So it states here, ma'am, that you wrote a letter on December 3, which you have affirmed, Supreme Court Associate Justice Teresita Leonardo de Castro called the attention of Respondent Sereno through a memorandum which was concurred in by several justices, stating that it was not true that the Court en banc ratified Respondent Sereno's act of reviving the Arcao 7. Justice de Castro manifested that the true consensus of the Court en banc did not appear in the November 27 resolution, which was to oppose the reopening of Arcao 7. And then in the next paragraph, it states that in that same memorandum, Justice de Castro said that Respondent Sereno was depriving the High Court. Anyway, ma'am, like I said, can you kindly explain to us and maybe read into the records and then explain the contents of your memorandum to the Chief Justice.
Before I do that, may I ask a permission from the Honorable Chair and Vice Chair to allow me to explain the background of the Regional Court Administration Office?
Please,
The-
please do,
Please,
Madam.
This issue about ARCAW started when on November 23, 2012, the justices, the associate justices of the court received an invitation coming from the Office of the Chief Justice, inviting us to attend the reopening of the Regional Court Administration Office in Region 7 on November 29. This was an invitation sent to us by the PS of the Chief of Staff of the Chief Justice. I was taken aback because we are invited only to a launching of the Regional Court Administration Office in Region 7, and we were not at all consulted and made to participate in this decision to reopen the Regional Court Administration Office. So this prompted me to look deeply into the matter, and I found out that the Chief Justice issued Administrative Order number 175-2012, designating the head for the Judiciary Decentralization Office in the 7th Judicial Region. Even the heading of this administrative order shows that this is not meant to implement the ARCAW as approved by the Court and Bank unanimously. I'd like to show to you the resolutions of the Court and Bank, which was also cited in the administrative order issued by Chief Justice Sereno. And if you will look at before that, the administrative order referred to AM number 0611-09 SC. And this was adopted on November 14, 2006, unanimously by all the justices of the Supreme Court. The resolution, if you will look at this copy that I brought here, bear the signature of all the justices that approved the resolution. And there is also another one, also mentioned by the Chief Justice, the resolution in AM number 06-1206 SC, pertaining also to the establishment of the Pilot Regional Court Administration Office. And this copy would show that this was again unanimously approved by all the justices of the court, with only one not able to sign it because she was on official leave. So both of these documents are en banc resolutions, which, according to the Chief Justice, she would like to implement. But when I compared the administrative order issued by the Chief Justice, it did not conform to the provisions of this administrative matter adopted by the Court and Bank. If I may be allowed to show to you a matrix that I prepared comparing the two, is it?
Do you,
Please, ma'am, do you have a...
Yes, I have
thank you, ma'am.
I have a PowerPoint
Yeah.
presentation.
please,
Ayan. Thank you, ma'am.
yung ilaw
This
dito.
is I made it very brief. I just pointed out the most significant provisions in this administrative matter adopted by the Court and Bank, which is on the left side, and Administrative Order number 175-2012 issued by the Chief Justice. So the en-banc resolution created the Regional Court Administration Office in the 7th Judicial Region. The administrative order created the Judiciary Decentralized Office, or JDO, for the 7th Judicial Region. It shows a deliberate act of not referring to the Regional Court Administration Office, which would place this office under the Office of the Court Administrator. So if it is a decentralized, judiciary decentralized office without any reference at all to the Court Administration Office, then this will be independent of the Office of the Court Administrator, and this will be contrary to law because it is the Office of the Court Administrator that assists the court in the administrative supervision of all courts.
Yes, ma'am, may I just give some insights? Because the creation of an office, creation of public office, is it legislative, judicial, or executive in nature, ma'am?
I also mentioned that in my
Yes, ma'am.
memorandum.
I'm just asking for our record.
The Chief Justice cannot create an office.
Because that power belongs to the
Yes,
legislature.
it is a legislative power.
Yes, ma'am. Not even the
Because-
Supreme Court can create an
Yes,
office.
yes.
Yes, ma'am.
So what she did is it appears that she created a permanent office. The ARCAO is not a permanent office. So even if it was created by the court, it is a pilot project. So it is an ad hoc body. So it has no permanency. So it will not come within the exclusive legislative power vested upon
Because not
Congress.
even the Supreme Court could create the office of the court administrator. Is that correct,
yes,
ma'am?
yes.
It was created by law.
No, the Office of the Court Administrator, yes, was created by OCA. And it precisely provides that it is the OCA which will assist the court in the exercise of its power of administrative
Yes, ma'am.
supervision.
You're referring to Presidential Decree 828,
Yes, as amended.
creating the office of the court administrator. In fact, ma'am, in that very same law, it states in Section 7 that the Supreme Court shall create such offices, services, divisions, and other units in the offices of the court administrator as may be deemed necessary, and for this purpose, the Chief Justice is authorized to adopt and implement the corresponding staffing patterns approved by the Supreme Court.
Yes, it is
That's
already-
why the Supreme Court can only create these offices because the law, Congress has delegated that
Yes.
power to Congress, and the Supreme Court, and the Supreme Court should adhere to the provisions of the law.
Yes, Your Honor.
Thank you, ma'am.
That is a valid exception to the prohibition against creating an office. If there is a
As long as there are
there
details
is
that
a
will
valid
guide the
delegation.
delegate. Yes, ma'am.
And aside from that, Your Honor, since the ARCAO is only a pilot project, it is explicitly, these resolutions of the Supreme Court provides that it is only for a one-year period. It's a pilot. They're just testing how wise it is to come up with a decentralized office like the ARCAO. So,
Proceed, ma'am.
the other item that provision that departs from the resolutions of the court is that, as I mentioned, the ARCAO is a pilot decentralized unit implemented over a one-year period. But the administrative order issued by the Chief Justice says that it is effective immediately until revoked by the Chief Justice. So there is some kind of permanency, and it is up to the Chief Justice to decide until when this JDO will exist. Now, the other item is that the court administrator under court resolution is the implementation head of the pilot project. Now, in the administrative order of the Chief Justice, the judiciary centralized office head designated by the Chief Justice, who was at that time it was the program management office head, and not an official of the office of the court administrator. So this again would show that there's no connection between this judiciary decentralized office created by the Chief Justice and the office of the court administrator. Now, the resolutions of the court, the other item is that the official functions in the pilot ARCAO are vested in the following: the court administrator, the regional court administrator, the deputy regional court administrator, the assistant regional court administrator, and there is an oversight committee. Now, in the administrative order of the chief, the official functions are all vested in the head of the JDO. It made reference to the resolution of the court, only stating that the JDO head will perform all the official functions mentioned in the resolution of the court. Now, and the last item that I would like to note is that under the court resolution, the staffing pattern must be court approved, and the designation of ARCO personnel shall be approved by the Chief Justice upon recommendation of the court administrator. But Administrative Order Number 175-2012 states that the hiring of contractual personnel for the JDO for the 7th Judicial Region must be consistent with the staffing pattern approved by the Chief Justice. So because of this analysis, I decided to write the court en banc, and before the letter that you read into the records, there was an earlier memorandum which I sent to the other justices.
May we have a copy of that, ma'am? You only have one copy, ma'am?
I have it here. Now,
We'll just, okay, ma'am. We will copy it later. We'll produce
this
it.
is dated, saan ba yung date? Can see the date. It's November 26. Because I received the letter on November 20, the invitation on November 23. So I wrote a letter on November 26 and asked that this be placed in the agenda of the court en banc.
Is it lengthy, ma'am?
It's quite lengthy in the sense that maybe I can omit the grounds that I mentioned why I am opposing.
Can you read the relevant portions, ma'am,
Yes,
to our
Your Honor.
inquiry?
May I explain why I am the one who took the initiative to bring this up? During the incumbency of Chief Justice Renato Puno, I was appointed member of the Management Committee on Judicial Reform Support Project, and that is the committee that oversees the judicial reform projects of the court. Now, when the senior justices retired and Chief Justice Renato Corona assumed his position, I was promoted to chairman of the management committee that I mentioned. And this management committee oversees all the judicial reform projects, including the establishment of the pilot ARCAO. So among the justices at the time when this was reopened, I am the one most familiar with the circumstances surrounding the establishment of the ARCAO.
How long have you been in the Supreme Court, ma'am?
I've been there since 2007, so I'm now...
So almost 10 years that you have been a member of the Supreme Court.
Yes, almost 10 years.
And before that, ma'am?
Before that, I was 10 years I served as first Associate Justice of the Sandigan Bayan and then Presiding Justice of the Sandigan Bayan. And before that, I spent 19 years of my government service at the Department of Justice. And before that, I worked in the Supreme Court as a young lawyer for 5 years.
Yes, I remembered appearing before you in the Sandigan Bayan.
Yes, so I now have a total...
I was acquitted.
Yes.
Thank you, ma'am, for the acquittal.
Yes, he was acquitted. So I'm now in my 44th year in government service.
Establishing, para po malaman ng publiko kung gaano po ka-extensive yung background ni Justice De Castro sa batas at sa judikatura. Please proceed, ma'am.
So, because of that position in Mancom, I was the one very much interested in looking into the matter of the reopening of the ARCAO. Because I know even then that there were a lot of problems encountered in the reopening of the ARCAO. It was the resolution that I mentioned, which provided for the establishment of this pilot ARCAO, was issued in 2006. And so, at the time that Chief Justice Sereno reopened this, she said she's reopening it but she's setting up a different organizational setup in decentralizing Region 7.
And without authority of the court and bank.
Yes, in fact, as I mentioned, we were just sent invitations to attend this reopening, which she said will be held in Radisson Blu in Cebu. And like the other court officials and personnel, the justices were invited. I have here two administrative orders, one number 85-2012 and the other one 86-2012, where you can see how many court officials and judges the Chief Justice had invited to attend that launching at the expense of the Supreme Court.
You have copies of also of those papers,
Yes,
ma'am? Yes, ma'am.
I have here the copy. So
Can we go back to that letter that you referred to a while ago, ma'am?
Yes,
Yung
this
highlights
is-
po, ma'am.
this letter, I'd like to show that I've always been very courteous and respectful to the Chief Justice. So even if I'm so much aghast at what she has done in issuing Administrative Order number 175, in this letter, in this memorandum to the justices and to the Chief Justice, I said, with due respect to the Chief Justice, her creation of the Judiciary Decentralized Office would not be in consonance with the en banc resolutions issued by the court, which established not a JDO, but a pilot regional court administration office, or PRCAO, and designated not a judiciary, a JDO head, but a regional court administrator who is under the direction and supervision of the court administrator as the implementation head of the pilot project for Region 7. Now, under Administrative Order 175, the Chief Justice designated the Program Management Office Chief, Geraldine Faith Ekong, as head of the JDO for the 7th Judicial Region on full-time basis and completely relieved her from all PMO functions and responsibilities. Then I cited some of the provisions of the Administrative Order. This matter should be taken up by the Court and Bank session on November 27 for deliberation and collective action of the Court and Bank. At the outset, I cited here the pertinent provisions of the Constitution, relevant laws, and en banc resolution. The Constitution provides for a collegial Supreme Court with the power, among others, the Supreme Court shall have administrative supervision over all courts and personnel thereof. Moreover, PD 828, as amended, as mentioned by the Honorable Vice Chair, creating the office of the court administrator in the Supreme Court and providing funds therefor and other purposes, provides as follows. The Constitution vests the Supreme Court administrative supervision over all courts and the personnel thereof. Now, and this law says, there is hereby created in the Supreme Court of the Philippines an office of the court administrator to assist the said court in the exercise of its power of administrative supervision over all courts as provided in Section 6, Article 10 of the Constitution. So, and then I mentioned some of the provisions of the en banc resolution on the pilot ARCAO in Region 7 are as follows. So I cited the creation, the vesting of the authority on the office of on the court administrator as the implementation head, and the authority designating, defining the authority of the regional court administrator, the deputy court administrator, and other officials of the ARCAO. And there is also an oversight committee for the pilot regional court. So I just cited the relevant provisions of the resolutions.
Ma'am, that was November 23, the date of that letter.
Yes, Your Honor, it's 26 already.
Your letter.
Yes, the invitation was dated
Yes, ma'am.
November
And then
23.
the following day, you had the en banc session.
27, Your Honor.
Yes, ma'am. And what happened? So, before the en banc session, it's
I
now
need to
established, ma'am, that you already called the attention of the Chief
everyone.
Justice about the
Yes.
irregularities in the creation of this JDO. What happened during the en banc session, ma'am? Did you take the matter up?
Yes, Your Honor, we took this up during the en banc session, and we deliberated on it, and I explained my position. I also mentioned that during my time as head of MANCO...
And the Chief Justice was there, ma'am?
Yes, the Chief Justice
Yes.
was there. And I mentioned that during my time, I was able to push for the approval of the Enterprise Information System Plan, the judiciary-wide computerization of the entire judiciary. And I said that, well, you see, this pilot ARCA was envisioned in 2006. It's now 2012. So many things have happened in the meantime. So there are so many supervening events. And I said we should review and study the reopening of the ARCA if ever it is to be reopened. And she cannot do it by herself because she has only one vote. And unless there is a delegation of authority from the court and bank, the Chief Justice cannot exercise the administrative power of as the administrative supervision of all courts, which is vested in the Supreme Court as a collegial body. So, in the course of the discussion, the justices also agreed with me. In fact, one justice said, "Why did you designate Geraldine Ekong of the Program Management Office? She does not belong to the Office of the Court Administrator. She has no business heading this decentralized judiciary office."
Can you name the justice, ma'am?
Huh?
Who was the justice? Or you would rather not? Of course, ma'am.
Well, and let me think about it.
Yes, ma'am.
There's another justice who said, "Oh, why Geraldine Ekong? She led the protest against the Arcao when she was a judge in Cebu. She even wore a black armband to show her opposition to the Arcao." So now you see, so as not to embarrass the Chief Justice.
How many justices were present then, ma'am?
I cannot recall anymore, but we're almost complete
Yes,
at
ma'am.
that time. Now, so in the course of the deliberation, the justices said, okay, so as not, let's just make Geraldine Ekong the head of a study group. So as not to embarrass the Chief Justice, because she already designated Geraldine Ekong. So the justices decided, let's just make her the head of the study group to look into the feasibility and the wisdom of opening the Arcao.
Ma'am, were you present then, Justice Marquez?
Hindi po siya.
Your Honor, not during the en banc deliberations. I think Justice De Casa was talking about en banc deliberations during that time.
Okay. And who was the clerk of court there, ma'am?
Kaya po,
Kayo lang po talagang...
when we hold the deliberations, we do not allow
Puro executive sessions.
Yes, always in executive session.
Pwede rin natin gayahin yun. Maganda yata yun.
So, because of these exchanges among the justices, it was very clear. The message or the decision of the justices was very clear. Just create a study group. And the Chief Justice even said, I will amend my administrative order. So I was relying on that. So after 2 days, since in our procedure, it is the Chief Justice who takes down notes and then directs the Clerk of Court to issue the resolution.
Responding resolution.
The resolution which will embody the decision reached by the court during the deliberation.
Ma'am, even if your testimony were not under oath, I would believe your statement, ma'am, but could you name some other justices who could collaborate?
The
what
Tapusin
you're
ko po
saying.
muna yung aking
Oh,
istorya.
tinatanong ko lang po, ma'am, kung meron po, kasi baka sabihin ni Chief Justice, gawa-gawa lang ni Justice Sereno. Meron po kaya?
Kung meron po akong dokumento, magpapakita na tama yung aking
Ay, tama,
sinasabi.
eksakto
Meron
na po
naman
yun.
yung documentary evidence eh.
Yes, ma'am.
I do
Please.
not want to burden my colleagues.
Yes, ma'am. Please proceed, ma'am.
Oo. So, maybe about, I cannot recall anymore, maybe about 2 days, I gave time to the Chief Justice to prepare the resolution because it will also take time. There are so many items in the agenda. So it was after a few days that I called up the clerk of court and asked for a copy of the resolution. So ganito ho yung conversation namin. Pwede ba makahingi ng resolution yung tungkol dun sa ARCAO na pinag-decide namin noong nakaraang Tuesday? Sabi ni Chief, babaguhin niya yung administrative order niya. I want to see how it was done. Ho, sabi niya, sabi ho niya, ni-ratify niyo daw eh.
Sino po itong kausap ninyo,
Si Clerk
Madam?
of Court, Enriqueta Vidal.
Vidal.
Retired na po. Pero siya ho yung kausap ko. Ngayon, ito ho yung binigay niya sa akin. Yung hong ratified. Yung ratify.
Ito po yung notice. Ito po yung notice na meron po
Oo.
kasi kami dito,
Ito
notice
po.
issued and bank, nakalagay, please take notice that the court and bank issued a resolution dated November 27, 2012, which reads as follows. Nakalagay na po doon, paragraph A is to ratify and paragraph B is to appoint. Ito po ba yung, is it the
Opo.
same resolution we're talking
Yes,
about?
this
ma'am?
is the resolution that I asked, that was given to me by the clerk of court. I got hold of a copy of this, and so that prompted me to write again. That
Ma'am,
is,
for the record lang po, may I read, and kindly correct me if I deviate from it. It says here, AM number 12-11-9 SC, reopening of the Regional Court Administration Office, ARCAO, in Region 7. The court resolved to A, ratify the action of Chief Justice Maria Lourdes P.A. Sereno to revive the Regional Court Administration Office in Region 7 with Phase 1 on letter A, procurement, letter B, approval of leave, and letter C, payroll and administration, and subparagraph B, appoint Judge Geraldine Faith A. Ekong, Deputy Clerk of Court and Judicial Reform Program Administrator as officer in charge of ARCAO Region 7, effective immediately and for a period of 2 months. Brion J. on leave, Reyes and Perlas, Bernabe, Justices, JJ on official leave. Ito po ba yun, ma'am?
opo, yan po.
Yes,
so,
ma'am.
tatlo po pala yung absent nung time na yun.
Opo, ma'am.
Pero, so, nandun, 12 po kami nandun.
Yes, ma'am.
So, because of that, I had to write the letter that you read also
Yes, ma'am.
earlier.
Please, so this evoke or provoke your writing a letter, and now kindly read.
Oh, yes. That was my second letter. That
This is December 3.
After I got hold
Opo.
of this resolution.
Parang December 3 na po ito, ano?
Opo.
Yes, ma'am.
Immediately, I wrote again another letter where I...
This is the one I showed you earlier, ma'am.
Yes, Your Honor.
May I ask Justice Marquez to read the letter, ma'am?
Oh,
Para
yes.
naman po.
Gusto ko pa nga pabasa
Yes,
kasi
ma'am.
this shows how I regard highly the chief. I always show respect and courtesy to her, even if I've seen something wrong with what she has done. Still, when I write a memorandum opposing whatever she had done, I was very respectful and courteous to her. So I would like
Justice Marquez, kung pwede lang po, kung hindi, ako na lang po, but mabuti na yung galing din sa court administrator.
Sige po. The letter starts with, and I quote, I regret that I have to write this memorandum in connection with resolution in AM number 12-11-9-SC, supposedly adopted by the Court and Bank on November 27, 2012, a copy of which I received this morning. With due respect to the Chief Justice, to my recollection, the resolution does not reflect the court's deliberation and consensus of the justices. Open parenthesis, no dissent was expressed, close parenthesis, opposing the reopening of RCAO 7 when the said administrative matter was taken up on November 27, 2012. That's the first paragraph. Would you like me to proceed, Your Honor?
Yes, importante yun.
Please, dahil very relevant po lahat eh. It addresses the allegations
Okay.
point by point. Kasi, para po.
In fact, second paragraph, in fact, at the end of the deliberation, after hearing the vehement objections of the justices to her administrative order, AO number 175-2012, designating the head for the Judiciary Decentralized Office, JDO, in the 7th Judicial Region. If I may quote the Chief Justice, she said, and I quote, "I will amend my administrative order, period, close quote." The objections raised during the deliberations regarding the said administrative order, AO, were not rebutted or disputed.
Nakalagay where? Because
Were
enumerate.
not rebutted.
No, nakalagay. The objections raised during the deliberations regarding the AO were not rebutted or disputed were. Yeah.
So the next page na po.
Magaling yata ako bumasa kaysa kay Justice Minor.
Sir, medyo malabo ho yung kopya ko. Pasensya na po.
Pakibigyan si Justice na mas maliwanag ko.
Page 2, the Chief Justice, number 1, the Chief Justice has no authority to create a Judiciary Decentralized Office, which under the AO shall take full responsibility over the Regional Court Administration Office in Region 7, which has to be reopened without court and bank approval on November 27, 2012. Number 2, the AO of the Chief Justice cannot deprive, number 1, the court and bank of its constitutional duty to exercise administrative supervision over all courts and their personnel, and 2, the Office of the Court Administrator of its statutory duty under PD 828 as amended to assist the Supreme Court in the exercise of said power of administrative supervision, which is the case under the AO where an official outside of the Office of the Court Administrator was designated to take charge of RCAO 7, answerable only to the Chief Justice without any guidelines set by the court and bank. Number 3, the RCAO 7, which was intended only to be a pilot project, cannot be reopened or revived on a permanent basis, even on a limited scale, without first undertaking a study, particularly among many other concerns, why it failed when it was first organized, resulting in black armband rally against RCAO 7, organized by judges and court personnel in the region, led by Program Management Office Head, then RTC Judge Geraldine Faith Tekong. Number 4, RCAO 7 cannot be reopened without showing to the court the content, scope of the functions to be transferred from the Office of the Court Administrator to RCAO 7 and the process of decentralization or devolution of functions and the justification for the reopening. Number 5, the PMO head cannot be appointed in charge of RCAO 7 since it is not part of her duty to assist in the administrative supervision of lower courts. At best, a justice opined she may take part in the conduct of a study for a period of, say, 2 months to determine whether or not to reopen RCAO 7. Number 6, the court and bank, which is constitutionally vested with administrative supervision of all courts, has the authority to decide on the reopening of RCAO 7, and it must be assisted by the Office of the Court Administrator. Number 7, Administrative Order Number 175-2012, dated November 9, 2012, which was reiterated in Administrative Order Number 185-2012, dated November 27, 2012, has transgressed the said constitutional authority of the court and bank and the statutory authority of the Office of the Court Administrator. In view of the foregoing, the court and bank did not reach a decision to reopen RCAO 7. Instead, it accepted the undertaking of the Chief Justice to amend AO number 175-2012 to address the foregoing adverse observations of the justices during the deliberation on November 27, 2012. The resolution dated November 27, 2012, ratifying the action of the Chief Justice reviving RCAO 7, which she did through Admissive Order number 175, 2012, and appointing the PMO head as officer in charge of RCAO 7, must be recalled or amended to faithfully reflect the deliberation of the court and bank, particularly the objections raised against the said AO. Respectfully submitted, signed Teresita Leonardo de Castro.
Thank you, Justice Marquez. Very clear po yung letter, so we will not even ask questions about it. Now, my next question would be, ma'am, did the Chief Justice reply to this letter, memorandum that you sent?
Hindi po. She did not reply at all. Even during the deliberation, she did not explain why she issued Administrative Order number 175.
So following this letter dated December 3, 2012, what happened to that RCAO 7, ma'am?
Matter was again taken up on December 7.
At whose instance, ma'am?
Because of my pending memo,
Which you
where there is-
furnished the other justices?
Yes, and
ma'am. So it was included in the agenda?
yes, it
ma'am.
was included in the agenda, so it was taken up again on December 11, where the court reiterated that there should be a study committee. But this time, it was decided that instead of Geraldine Econg, it will now be one of the associate justices, Jose Perez, who will head the study group. And I have here the resolution in AM number 12-11-9-SC, creating a needs assessment committee to study the necessity of decentralizing the functions in support of the Supreme Court's power of administrative supervision over lower courts. Now here is where it is mentioned.
Yes, ma'am, please.
Here it is mentioned that, so in the whereas clause, there is here a confirmation that on November 27, we decided that there should be a further study on this RCAO before it is reopened. So the first whereas clause states, whereas on 27 November 2012 and on 11 December 2012, the Supreme Court en banc, considering the operational inactivity of the pilot project under AM number 06-11-09-SC, determined that there is a need to further study the decentralization functions relative to the Supreme Court's power of administrative supervision over lower courts. Now, therefore, the Court hereby resolves to create a decentralization needs assessment committee to study and determine the necessity of decentralizing administrative functions appertinent to the exercise of the Supreme Court's power of supervision over lower courts. The function to be devolved, the implementation of the devolution of functions, and the efficient and effective performance of the devolved functions. The committee shall be composed of the following: Chairperson, Honorable Jose Portugal Perez, Associate Justice. Members, Jose Maidas P. Marquez, Court Administrator. Honorable Raul B. Villanueva, Deputy Court Administrator. Honorable Jenny Lind A. De Lorino, Deputy Court Administrator. Honorable Telma C. Bahia, Assistant Court Administrator. Attorney Lilian Baribalco, Chief Financial Management Office, Office of the Court Administrator. Attorney Catridad Pabello, Chief, Office of the Administrative Services, Office of the Court Administrator. Attorney Regina Adoracion Filomena Ignacio, Chief, Office of on the Halls of Justice, Office of the Court Administrator. Judge Geraldine Faith Econg, Judicial Reform Program Administrator, Program Management Office.
So in effect, ma'am, the erstwhile head of the JDO was made an 8th member of this.
Yes,
New committee.
and majority are all from the Office of the Court
I noticed,
Administrator.
and it's headed by a justice of the Associate Justice of the Supreme Court, and the court administrator himself is just a mere member. Yung create po ng Supreme Court. And what
Ito po.
really strikes me, ma'am, in this circular is the second to the last paragraph. It states, this resolution supersedes all prior resolutions, administrative orders, and issuances on the covered matter and shall take effect immediately upon its promulgation.
This is
It
a
will give me
subtle-
the impression, ma'am, that the court and bank really sided with your letter
Yes.
dated December 3.
Yes,
Do I
and-
get the correct impression, ma'am?
Yes, that's right. And this is a subtle way of overturning instead of
Diplomatic.
saying revoke.
Opo.
So
You
they-
pulled you pulled the words out of my mouth, ma'am, that it
Yeah.
was subtly rebuking the Chief
Yes,
Justice.
because the court did not want to embarrass the chief.
Opo.
And on my part, I'm not after putting her down. I just want to correct what has been done. To put things in its to put things in the proper order as decided by the court in the previous resolutions.
Would you know how the Chief Justice reacted to this mild or subtle
She
way
didn't
of
say-
rescinding her
No,
unauthorized creation of a JDO, ma'am?
no, she didn't say anything. She didn't answer my letters. She didn't do anything.
Do you agree with me, ma'am, that this was to be blunt about it, that the Supreme Court really rebuked the Chief Justice on this matter by revoking her administrative order, creating a JDO?
In effect, the November 27 resolution was not approved or was set aside. But there's no such express setting aside. But you can get that idea from the
Yes, ma'am.
resolution, the creation of the...
Mr. Chairman, in view of the testimony of Justice Castro, may we invite former Clerk of Court Enriqueta Vidal to appear before this committee to shed light onto the regarding the issuance of that resolution, which is not in consonance with what was discussed by the court and bank.
Let the invitation be issued. I hereby direct the COMSEC to issue the necessary invitation.
Ma'am, I would have several questions, but do you want to add something more regarding Arcao 7, ma'am?
May I ask Court Ad Marquez to explain to you what ARCAO is all about and
Please,
why was
Mr.
it
Justice
not
Marquez.
operation?
Thank you, Your Honors. Briefly, no, the Regional Court Administration Office was actually included in the resolution of the court and bank, which the court, which the justice says unanimously approved, no? And this is in 2006 during the term of Chief Justice Panganiban. No? It is implementing the pilot project on enhancing fiscal autonomy, accountability, and efficiency of the judiciary, and improving the administration of justice, establishing and operationalizing the pilot organization infrastructure, providing for general implementation arrangements and other purposes. That was during the time of Chief Justice Panganiban, November 14, 2006. No? Chief Justice Panganiban retired in December 2006. He was replaced by Chief Justice Puno, no? In December of 2006. On July 17, 2007, pursuant to that earlier resolution of the court and bank, which was adopted unanimously, the court established ARCAO 7, no? And ordered the implementation of startup activities in Region 7. That is actually in Lapu-Lapu City. That was during the time of Chief Justice Puno, July 17, 2007. And as mentioned by Justice De Castro, the designation of the Office of the Court Administrator as the implementation head of the pilot project, defining the court administrator's authority and responsibility. 2007 po yun, hindi pa po ako ang court administrator nun. In in January 2008, the court began designating officials, no, to that RCAO 7, and they were holding office in the Hall of Justice of Lapu-Lapu City. No? So the regional court administrator was designated, deputy regional court administrator, and assistant court administrator for pilot RCAO in the 7th region. No? In March 2008, that was already, we were already holding office in Region 7. So what we did was and this was for, this was solely for administration and financial management. No? So when we say administration, the administration of the courts in Region 7. No? And then for financial management, that means the salaries, wages of the justices, of the judges and the court personnel in Region 7. We have more than around 150 judges in Region 7 and around 1,500 court personnel in Region 7. No? So what we did was we transported physically records, no, of the judges and court personnel from the head office in the Supreme Court and physically transported them to Lapu-Lapu City. No? And as I've said earlier, we designated, appointed officials to man that RCAO 7. No? The problem there actually was the designated officials were designated in a temporary capacity. Why? Because it was merely a pilot project. Okay? So, we designated clerks of court of different courts in Region 7. So we asked for volunteers, so clerks of court, court personnel in Region 7. We asked for volunteers if they wanted to be stationed in Lapu-Lapu City, where the RCAO 7 is a holding office. No? And some of them agreed because, if I'm not mistaken, around that time, they were given 20% allowance about over and above their regular salary, no? So, meron po tayong mga officials from Dumaguete, pumunta ng Lapu-Lapu, and from the other cities, no, and municipalities, which is not really exactly very near Lapu-Lapu City, no? The problem there is, well, they were supposed to compute the salaries and wages of all the judges and court personnel in Region 7. And then after they're able to compute the salaries and wages of allowances of these judges and court personnel, they will transmit that computation to Manila for Manila office to release the funds for their salaries and wages. Ang naging malaking problema po doon, marami pong sa mga nag-volunteer, no, to head that office, with no offense to the lawyers, mga abogado po na medyo nahirapan magbilang, mag-compute. Kaya po nung pinapadala, binabalik sa head office yung computation, isang tingin pa lang po ng ating head ng finance office, nakikita niya na mali. So sabi niya, hindi tayo pwede mag-release kasi mali-mali itong computation. No? So sabi naman ng mga nasa Cebu, hindi naman pwedeng ma-delay ang aming mga sweldo dahil dyan. So medyo nagkakagulo po, and that was, I think, one of the reasons why there was a black armband protest in Cebu City. No? And this went on, of course, the court or the office or the OCA, no, tried to remedy this, but this went on, no, until mga October, November 2008. No? Back then, that was the time of Chief Justice Puno. I was the Chief of Staff, no, of Chief
Who
Justice
was the
Puno.
OCA then?
Justice Jose Perez. Former OCA who eventually became Justice of the Supreme Court.
Parang ikaw din siguro, future justice ka rin siguro. Yung mga OCA pala nag-Supreme Court. Okay, please proceed.
Dito lang na muna po tayo. So medyo nagkakagalo po nun, I just instructed the head of the finance office that you cannot delay the salaries and wages of our judges and court personnel in Cebu or in Region 7. More so, Christmas is fast approaching. Ang sabi ko po, kung mali-mali po yung computation, i-release nyo na lang muna. Anyway, these judges and court personnel will still be there the following months. So, you just correct it the succeeding months. Kung merong overpayment, bawasan sa susunod na buwan. Kung may underpayment, dagdagan sa susunod na buwan. But we cannot delay the release of their payment. No? So, that was December 2008. And then because of the series of errors or it was not working as it was envisioned, no? Chief Justice Puno and I met, and he said, bakit ba yung mga sweldo at saka mga allowances ang dinala doon kaagad? Because at that time, Chief Justice Puno was going around the country, and I was, because of our Enhanced Justice on Wheels project, and I was accompanying him. And during our EJAW project, meron po dong dialogue, no, with the judges and court personnel of the certain area. So alam po ni Chief Justice Puno kung ano talaga ang mga nangyayari sa mga courts nationwide. So he was telling me, di ba umiikot tayong dalawa, hindi naman natin naririnig na problema yung sweldo. Bakit yan ang unang ni-roll out dyan? Ang naririnig natin na problema ng ating mga courts are the supplies, no? Hindi dumadating ng tama, kulang, gano'n. So, bakit hindi yung supplies ang unahin natin? Yan ang i-decentralize natin. So, sabi ko, sige po, subukan po natin yan, but we will have to start with Regional Bids and Awards Committee, which our judges and court personnel outside, or our judges and court personnel are not familiar with, no? So, sabi niya, paano dapat gagawin yon? Well, we will have to train them, no, how to conduct bidding for their regional supplies and equipment. So, ang nangyari po noon, no, slowly we were winding up the activities of financial and administrative functions of the Arcao 7, and we began training, no. Tatlo po yun ang ginawa namin, no? Kasi nga decentralization. In Region 3, Angeles, Region 7, Cebu, and then Region 11 in Davao, no? We started forming Regional Bids and Awards Committee, but we had to train our judges, no? Kasi yun ang nakita naming problema, no? But while we were training them, si Chief Justice Puno nag-retire 2010, no? May 2010. Pumalit po si Chief Justice Corona, tinuloy po yung training of judges and court personnel on Regional Bids and Awards Committee processes, no? Kaya lang po hindi naman masyadong tumagal din si Chief Justice Corona. Pag-upo po ni Chief Justice Sereno in 2012, no? August 2012, medyo nahinto po yung ating Arcao because we were waiting for further instructions, no? So pagkatapos po, ang nangyari doon, yung pong inilahad na po ni Justice De Castro.
Thank you, ma'am. Ito na lang po. In fact, looking at the resolution under question, which appears to have been fabricated, effective immediately and for a period of 2 months. So even with the purported action of the court and bank, 2 months lang yung appointment niya. As compared to the AO issued by the Chief Justice just 2 weeks before, yung kay Chief Justice, this order shall take effect immediately and shall be effective until revoked by the undersigned. So, open-ended na po yung appointment ni Justice Ekong as head of this new created office, a JDO, na hindi naman po Arcao na, kundi naging JDO. So, not even I think the Supreme Court could do this because hindi na nga ako ginawa ganun. Now, ma'am, last question. Do you think that the issuance of this AO number 175/2012 is a violation of the Constitution and the law?
Trying to answer that
Yes, ma'am.
question.
I respect that you decline, but may I just read your letter, ma'am? Your memorandum in paragraph 7, it states, Administrative Order 175-2012 dated November 9, 2012, which was reiterated in Administrative Order number 185-2012 dated November 27, 2012, has transgressed the said constitutional authority of the court and bank and the statutory authority of the OCA. Yun po yung nandito. So, okay ma'am, I will take, you're not answering it, but anyway, you have stated it very clearly in your letter dahil yung nga ho ang tingin ng iba dito at yung complainant na nilabag ng punong hukom ng Korte Suprema yung Constitution dahil yung karapatan o kapangyarihan na linaad ng saligang batas para doon sa buong Supreme Court, ginagampanan niya ng sarili lamang niya. At dito po rin sa panig namin sa Kongreso, pati po yung PD 828 na isang batas, inilalabag din po dahil nag-create na po siya, nag-a-appoint siya na hindi approved by the Supreme Court, and the law clearly states that she can only appoint staff with approval of the court and bank. Thank you, ma'am.
Sana ho sa paliwanag ni Court Ad Marquez na intindihan na ho sana ng lahat bakit kailangan kong gumawa ng hakbang para pigilin yung pagbubukas ng JDO sa Region 7.
Because of that, I'll have to ask another question. What did you do during all this time, Mr. Court Administrator? Did you not call the attention of the Chief Justice na, ma'am, baka paglabag na po ito ng batas at sa Constitution dahil you are creating offices that are decentralized from your office while you are tasked. Ma'am, sir, your office was created by the law and tasked by the law to perform all of these functions, yet the Chief Justice is now going outside of the ambit of the delegated power by Congress. Ano pong ginawa niyo nun?
Your Honor, I think the creation was done sometime November 2012. Chief Justice Sereno assumed office sometime August. So nung na-create po yan, hindi ko rin ho alam na merong ganun. So nakatanggap na lang din po ako ng instructions to proceed to Radisson Blu for the launching.
Okay, so what was your reaction upon reading this AO? As the court administrator tasked by law to perform these functions, to you upon whom these powers have been bestowed upon by law?
Well, the first time I came to know about it was the launch already, no? So nakahanda na po doon, nasa Cebu na po kami, meron na pong program. So medyo pinabayaan ko na lang po muna, no? But after that, sumulat na po si Justice De
I
Castro.
know, but I'm asking you about your position as the court administrator. Do you think that action of the Chief Justice was warranted? Sir, you are holding a high position with commensurate to the rank of the presiding justice of the Court of Appeals. Tama po ba yun?
Yes, sir. Tama
Yes, sir.
po.
And then, so, kayo po yung, you are the one performing the functions of an office created by law. We are the lawmakers. So we are asking you now, what would be your take on this administrative order creating a decentralized office outside of your ambit?
Your Honor, as court administrator, I take instructions only from the Chief Justice and or the court and bank. So, kung ano po yung inuutos sa akin, unless talagang napag-aralan ko na pong mabuti na medyo hindi tugma, no? But at that time po, hindi ko po nakita yan eh. So,
I'm asking you after the fact, Justice. Alam ko, before the issue was, di mo alam, but after the fact, nung nakita mo na, are you refusing to answer to invoking your right to incriminate yourself or
Pwede
Yan
ho
ang,
bang-
you know,
Pwede ko
I
ba
address, ma'am, before that, I address this to the Congress as a body. That's the defect of the present constitution that we have because of the Judicial and Bar Council. The Judicial and Bar Council is under the supervision of the Supreme Court or the Chief Justice. Kaya po, dati, wala po pwedeng maging hukom o justice kung hindi dadaan sa commission and appointments. Kasi nga po, yung binuo na Judicial and Bar Council, iisa lang po ang elected official dyan, yung member of representative of Congress, hinati pa. Halin-hinan pa yung pag-upo doon. The commission appointments may have its faults, but it's still the best system practiced even by the United States of America. You cannot become a justice if you don't face the duly elected representatives of the Filipino people because judges and justices hold sway on the life, liberty, and property of people. Kayo po nagde-decide niyan eh. Kung sino makukulong, kung sino mabibitay, kayo po nagde-decide. Yet, hindi po kayo accountable directly to the duly elected representative. Kaya si Justice Marquez, natatakot eh. Naku, baka ma-recommend ako sa JBC, o objectan ako ni Chief dyan, hindi na ako magiging justice. I understand. I understand his
Maraming salamat po, sir.
Yes, sir. I understand his reluctance.
Sinabi mo pa.
And lahat po ng promotion from judges, lahat, wala. Yung JBC na lang po ang nagde-decide dyan. Ang dumadaan lang po sa amin ay yung 3 nominees nyo, dumadaan po sa 4, dumadaan po sa commission on appointments yun. Nung I was the majority leader of the commission on appointments, kami po nag-approve. Yun na lang po, pero baliktad din po ang procedure eh. In the commission on appointments, the president nominates or appoints ex officio subject to confirmation or rejection by the commission on appointments na 12 senador, 12 kinatawan ng House of Representatives po ang mag-a-approve nun. Kaya nga po nakikita nyo ngayon, ilang pong cabinet member hindi lumulusot. Ito, appointed na rin ng president, pero may process po. Dito po sa JBC, baliktad po eh. Magbibigay na lang yung JBC ng listahan sa Pangulo. Kaya maski yung good, better, best, not too good, bad, kung 5 yan, pwede mapili yung not too good or yung bad. And that's it. Kasi nga, the JBC just submits 5 to the president. Hindi mo alam kung sino doon ang mapipili. And then the president will just pick who will become the Chief Justice or judges without any correction after that. Kaya hindi po nasasubject much to a stringent questioning kung sino magiging Chief Justice because you don't actually know who will become the Chief Justice. Correct po ba, ma'am? Ganyan po nangyayari, even justices. So, because of palakasan or influence, isama mo naman na yan. Basta masama dyan, okay na. Masama lang na nominee sa shortlist. Mas shortlist lang eh. Pang-5 siya, ang score pala niya, number 3 lang, 3 lang nakuha niyang points. Yung iba, 5, 6, 7. Eh yung number 3, yung napipili ng presidente, tapos. Wala na pong
Incidentally,
accountability.
majority,
So,
you know, that is also another issue, yung JBC manipulation of the nominees and list that will fall or covered by the JBC. No? And there is an issue on clustering. And this is part of what we requested these resource persons to testify on. So,
in this connection, Mr. Chairman, that's why when it comes to impeachment proceedings, the more we should be strict with justices of the Supreme Court and the Ombudsman. Sila lang po kasi yung hindi dumadaan sa CA. The President and Vice President are elected by the people. The Chairman and Commissioners of the COMELEC, Civil Service, and COA pass through the CA. Yung mga justices po, hindi eh. So when it comes to matters regarding impeachable offenses, dapat lalo natin tinitignan yan para naman po ma-account sila. Kasi po, yung Supreme Court has the sole power to discipline judges and justices. Maski po yung Sandigan Bayan, hindi naman po impeachable. So sa Supreme Court na lang. Kaya yung bata-bata system minsan sa korte, pagbata ni Justice Kwan yan, hindi na po magkakakaso yan. Pero pag wala pong ninong, pwedeng madaling matanggal. Yan po ang kailangan i-review rin po natin. Thank you, ma'am.
So, any more clarificatory questions coming from other members on this particular issue alone on ARCAO? Anything else?
Yes.
Okay, so, ano yung second ground for which she was,
Mr. Chair,
So, the next charge for which...
Mr. Chair, I'm sorry, you were asking if there were any other members who wanted to ask further
Yes,
questions on the ARCAO?
For
I
this
have questions.
particular issue alone
Yes,
on the
yes,
ARCAO.
Yes, I have.
Are you, okay, you're now recognized, Congressman Rocamora.
Okay. Thank you, Mr. Chair. Your Honor, good morning. I'm addressing my question to Justice De Castro. I'm here. It would appear that from all these issues about this ARCAO 7, she is being charged of having created an office illegally. This is correct.
That is the tenor of my memorandum to the justices.
Okay. Now, if you say you created an office, that means there is no office that exists yet. That's why you have to create it. Is that correct?
Opo, wala po.
Okay.
Wala po.
Okay,
Ang meron
now-
po yung ARCAO.
Okay. Now, is it the fact that this ARCAO 7 had already existed since 2006?
Meron nga pong ARCAO pero iba po yung kinreate ni Chief Justice, Judiciary Decentralized Office. Kasi po, ayaw niyang gamitin ho yung term na ARCAO kasi po papasok ho yun under the organizational setup ng Office of the Court Administrator. Kaya ho, pag binasa niyo yung kanyang administrative order, there is nothing there about the Office of the Court Administrator. She deliberately omitted in the entire Administrative Order 175 any reference to the Office of the Court Administrator. Kaya ho, hindi niya tinawag na ARCAO. So misleading nga po yung sinulat sa amin ng kanyang Chief of Staff. Ang sinulat po sa amin, i-reopen daw ang ARCAO. But there is no such ARCAO that was launched. What was launched by the Chief Justice is the Judiciary Decentralized Office. Yung ARCAO ho, under the resolution of the Supreme Court, there are officials explicitly mentioned in the administrative order which will run the ARCAO. But that was not what the Chief Justice did. There is a different office, which is the Judiciary Decentralized Office, to be headed by the PMO, the Program Management Office Head, as JDO Head. So wala ho pa hong, bago ho yung administrative order ni Chief Justice, wala hong opisina. Misleading po yung imbitasyon na pinadala sa amin. Akala nga namin ARCAO, hindi pala ho ARCAO.
But before, as I understand, during the inauguration, a number of justices attended it.
Alin po? Which one po?
Launching, I'm sorry, the launching.
The launch? Wala ho nga, hindi ho dumaan sa court ho yun yung launch.
No, I was asking if a number of justices attended the launching.
Ang alam ko ho, nandun si Justice Leonin. At saka si Justice Mardel Castillo.
Veloso was not there?
Wala po. Ay, hindi ko po alam. Ay, wala ho.
Villarama.
Ay, wala ho yung mga ibang justices ho, wala ho.
Reyes?
Wala ho. Are you referring to the Supreme Court justices?
Yes, of course.
Wala po. Dalawa lang ho ang umattend. Si Justice Ang pagkaalam ko ho.
Were you there?
Pero I have no personal knowledge.
Yes, okay.
But I just heard that only two of us
You heard-
attended.
you
I
heard.
just heard about it. Nakita mo.
Marquez was there, of course.
Yes, Your Honor. I was instructed to fly to Cebu for the launch.
May I address this question to you?
Yes,
Were
sir.
these justices that I mentioned present?
As far as my recollection, I only saw Justices Mar del Castillo and Mar Viclionen.
So you did not see Villarama, Velasco, Reyes?
No, Your Honor.
Okay. Now,
Only those two SC justices and mostly court officials from the Office of the Court Administration, Office of the Court Administrator, and judges from Region 7 po.
now, with respect to this question, order or what's it, resolution, were there other justices that signified their objection in writing?
Wala po.
None. And what you are saying now is that they have just expressed this orally during the in-bank
Yes,
meeting.
yes, Your Honor. There were discussions.
Okay,
So,
and you say that these objections were not stated in the notes of the Chief Justice?
Nobody objected, Your Honor.
Nobody objected.
Yes, nobody objected.
Okay. So it's nobody objected. So the resolution was in fact voted in unanimously.
Which resolution po?
The resolution that was said to be falsified.
Hindi po yun yung aming hindi ho yun ang aming naging desisyon. Iba ho yung lumabas sa resolution. Hindi po ayon sa mga sa deliberation ng justices during the en banc session.
Were there minutes of this meeting, in-bank meeting?
It is the Chief Justice who writes down the minutes of the proceedings.
Yes, but was there no official minutes
po,
written
there's
down
no-
on this?
Wala po, we hold executive sessions during our en banc sessions.
And no official minutes were prepared by the clerk of court and furnished to the different justices?
We should be furnished, but I was not furnished. I just asked for a copy.
You say you should be furnished, so you say that there must be minutes.
There should be, but it all depends on the Chief Justice.
I believe that there were minutes of this in-bank meeting.
All our
We ask that a subpoena be issued
No,
for the
the-
production of these minutes, please.
What
The-
would you
the-
like to subpoena, Your Honor?
Yes, yes.
Can you please specifically state what your request is? Because we cannot subpoena the minutes. I do not know what minutes are. Please amplify that point.
This is
You
for
know,
the minutes of the in-bank meeting on November 27, 2000.
I believe the
2012.
answer was that there was no minutes, and I
No.
think, to my recollection and what I understand from the
Actually,
answer is that there was no minutes.
Actually, she said at first there were no minutes, but afterwards she said the minutes should have been circulated. So that presupposes that that the minutes do exist.
Honor, may I clarify?
Please, Madam Justice.
When we deliberate, we have an agenda containing all the items, all the
Okay.
cases. And as we go along, the chief would write down the action of the court. After discussions, he will write it down. And then, she will prepare the minutes, which will be given to the clerk of court. Now, since it is up to her to do that, and we are all very busy, we cannot keep track of the minutes that are submitted to the clerk of court. I do not know.
So-
I do not know what process the Chief Justice
The-
follows in the court and bank.
Then-
But in division sessions where I am the chair, what I do is that I circulate the agenda with my notes. And then once that is approved, it goes the agenda would go back to me, and then I will ask the clerk of court to prepare the minutes. And then after the minutes is prepared, I will ask again the members of my division to go over it to see if what I wrote down or what was reflected in the minutes are accurate. So that is our procedure. I do not know what procedure the Chief Justice follows. Mr. Chair.
So what is the pleasure now of the Honorable
So
Rocamora?
it appears that the notes of the Chief Justice who took the notes would be given to the clerk of court, who is this now? Enriqueta Vidal? May we know if Enriqueta Vidal is one of those persons who were issued a subpoena for the...
You see, Your Honor, Mr. Chair, can I... again
Okay,
make some
we have already invited Vidal
Yes.
as moved by the majority leader. So what?
May we add to the subpoena of Vidal? I believe that was only anti-Stefano. We would like to ask for subpoena ducis tecum for the minutes for November 27, 2012 in bank discussion.
She's already retired, so she may not be able to produce the minutes. But maybe the incumbent clerk of court.
The incumbent then.
The incumbent
Okay, so
clerk
we have already invited the incumbent clerk of court, Attorney Anama. And so, in addition to the subpoena, to the invitation, let a subpoena duces tecum be issued on the notes and or minutes
On the minutes.
and or minutes of the Chief Justice
Sereno.
with respect to this Arcao issue. Okay na po?
Okay.
Okay, so are you done?
Not yet.
Hindi pa. Sige po.
Unfortunately.
Please.
Now, when I came up with that first question, that she created an office. By the way, was Arcao 7 ever dissolved?
Court Ad Marquez to answer that.
Technically, Your Honor, ARCA was never dissolved, no? Because what I issued, I think sometime 2011 was just to wind up the financial and administrative functions in ARCA 7 because it was not functioning properly. And then we proceeded with another devolution, which is the procurement process in the different regions. So that's also part of ARCAO. No? But
Okay.
as I've mentioned earlier, when Chief Justice Sereno took office, we halted for a while to take instructions. No, but
You halted for a while. Yeah. Okay. So, what was your basis in issuing this winding up of the Arcao 7?
Your Honor, as head implementer of ARCAO 7 and upon discussions with both Chief Justice Puno and Corona, that was the decision arrived.
Was a resolution ever issued for that purpose?
No resolution issued for that purpose because, as I've said, we never scrapped ARCAO anyway. It was part of the implementation of the ARCAO.
So all the time, technically, Arcao 7 still exists. At the time that allegedly the Chief Justice created.
Technically, Your
An
Honor,
office,
because
this office.
it was never scrapped.
So in short, no office was actually created.
Your Honor, you mean the JDO?
To me, it's just a matter of nomenclature because it's the same decentralization.
Your Honor, anyway, what is important is what we can get from the witnesses, not how we will conclude it. So, anyway, please avoid misleading questions because we will get nowhere when we ask misleading questions.
This JDO and ARCAO, does it follow the same concept of decentralization? To Justice De Castro, please.
It did not follow the ARCAO because if you will look at the provisions of Administrative Order 175, it is very short. And the only reference there to the ARCAO is that ECONG, the head of the JDO, will perform all the functions under the resolution. Resolution.
Thank you. But unfortunately, it does not answer my question. My question was, does it follow the same concept of decentralization?
No, there are marked differences between the two.
The concept. There might be differences, but the concept of decentralization.
Only the idea of decentralization.
Okay.
But the details, it's not. There's no point of comparing because the AO does not state sufficient details for us to understand how this JDO will operate.
But nevertheless, it was, what was the term used, inaugurated or, no, the inauguration or the launching. Nevertheless, the launching was for ARCAO 7.
Launch the ARCAO 7.
Hindi po, ang nilaunch ho, JDO.
We would like to ask Administrator Maedas.
I think, well, okay.
Ito pala ang sinabi niya.
Justice De Castro received an invitation for the launch of ARCAO. But she was not present in the launch.
Okay.
I was present in the launch. I don't recall receiving an invitation for the launch of ARCAO. I just remember receiving an instruction to fly to Cebu for the launch of ARCAO. But when I went there, it was not ARCAO which was being launched, but JDO. Because then PMO head, now Sandigan Bayan Justice Ekong, was also present as head of JDO.
Was it clearly stated that we are launching here the JDO, not ARCAO 7?
Yes, Your Honor, because that is
Who made that statement?
Pero alam mo dito sa order niya,
Mr.
sinabi
Chair.
niya ARCAO.
okay, because when I went there, that was what was being launched. And I was there.
What was your basis for saying so?
Your
What
Honor,
is your basis for saying so?
I was there. I personally witnessed the
You were-
launch.
Yes, but what is it in the launching that made you say that it was a launching for JDO, not ARCAO 7?
Well, because
Be
number
specific.
one, Attorney Ekong at that time was being designated as JDO head.
I can
And not
seem to
ARCAO, not Regional Court Administrator.
In connection with the appointment of ICAO, Ekong, did you sign or do anything to affirm her appointment?
I remember signing something because that was after the launch, and I was requested to sign something designating her.
What was that something, please?
I think I think something like designating or extending her term as a head of that decentralized office. But
That
again,
decentralized office,
but
meaning
then again, Your Honor,
the ARCAO 7.
but then again, Your Honor, I did that because I was requested to do that after the launch and after all these administrative orders coming from the Chief Justice was shown to me.
Do you have a copy of that document that you signed?
Gentlemen, may I just raise a point of information? And if I may just invite the Honorable Rocamora to look at the Administrative Order number 175/2012, which is entitled Designating the Head for the Judiciary Decentralized Office in the 7th Judicial Region, where it was created here that JDO, and that this is where nandito ba yung kay Ekong? This is where the designation of the head of this JDO in the person of Judge Ekong is clearly stated. So that these are official records of the Supreme Court. In fact, this need not be proved. We can take judicial notice of this. So let us stick to the facts rather than ask questions that will tend to obfuscate this hearing. Nasa inyo na po ito eh. Pinag-aralan po
yes,
natin to. Di madali po sana tayo.
You are correct there. In
Thank
fact,
you.
it is clear that this Administrative Order number 175-2012 is based, as it states in the first sentence, pursuant to the en banc resolution of the court in AM number 06-11-09-SC, dated 14 November 2006. This refers to the ICAO.
Arcaw nga po.
ARCAO.
Pero iba na
ARCAO.
po ngayon. Iba na po ngayon. JDO na po ang pinag-uusapan. Kanya yun po siguro yung ina-explain ng witness na magkaiba po ito. At iba rin po dahil yung ARCAO, ang head nun is yung Court Administrator's Office. Kanya po, kung ibabalik po natin na ARCAO po ito, ay this is not what the evidence and this particular document states and provides. Di po ba? Kanya nga, so
Whether you call-
we are doing clarificatory questions and we are not getting closer to the clarifications that we need by insisting on our interpretation that this is not JDO and this is ARCAO. Because that is not what the records say.
Actually, the record says that it is, because
That is your conclusion, Mr.
The evidence
Your Honor.
speaks for itself.
So
It says
anyway,
pursuant
can we go to another point so
AM.
that we will not derail this hearing? Kasi po, malinaw naman po at naintindihan naman po natin ito. Kung dadalhin po natin sa iba yung ating interpretasyon, we might end up doing this forever. Because you will insist on your interpretation, others will insist on theirs. That is for us as a committee to make a decision on when we decide to vote on probable cause for this particular issue.
Mr. Chairman,
Sandali lang po, no? I'll just recognize Congressman Belmonte. What is your point, Congressman Belmonte?
May I just add something? If at all this is falsification, why was all this made in open? And in fact, invitations were made.
I do not know.
I just wanted to pose that question, because if it is, the purpose here is to falsify, why was it made openly? In fact, a launching had to made.
You know, that calls for a legal conclusion. Meron na po silang
I was just
present.
asking. I was just
Meron na
asking.
present kaninang PowerPoint dito, pinakita na yung difference of the ARCAO and the JDO. If you were here and if you were listening, you would have noted the marked difference between the two. Ano po? Kaya nga po, kung meron kayong interpretation other than that, then when we come to that conclusion on voting on probable cause, that is the proper time to ask that. No? Pero let us not deviate from the facts. Yun lang po ang sinasabi ko. And let us not ask misleading questions
Okay.
that will tend to obfuscate this hearing
Okay.
and the issue.
Can I continue for a few more questions?
Nirecognize ko lang po si Congressman
Sige.
Belmonte on the same issue po, no, Kongkit.
Mr. Chair, I think it would be proper if I just wait my turn and allow the Honorable Racomora to finish. And then
Okay,
turn
so
the chair around.
anyway, meron po tayong listahan dito. If I may just si Congressman Deputy Speaker Garcia, but sige, patapusin po muna natin si
Thank you, Mr.
Congressman
Chair.
Rocamora.
Your Honor, please, it is clear to this committee as well as the public in general that you figure greatly in the complaint of impeachment by Attorney Gadon. And the first question that naturally comes out is why? And the second is there bias? I think it is a natural question for everyone. So, Your Honor, please forgive me if I have to ask these questions. You were among those shortlisted to place Chief Justice Renatos, to replace, that is, Chief Justice Renato C. Corona in August 2012.
Po, kasama po ako ni Chief Justice Sereno nag-apply. Nung nag-apply po kami, pinasubmit kami ng 10 taon SALN.
Okay.
We were asked by
it's-
the JBC to submit SALN ho namin 10 years before we applied. So
Okay,
2012 po yun, dapat may SALN po from 2002 up to 2011.
with due respect,
that was when,
Justice,
that was a requirement
the question
of
is
JBC.
answerable, yes or no?
Yes,
Thank you.
yes, and I'm just
The second
mentioning
question is, at the time you had been a member of the Supreme Court for about 5 years, correct?
that. Yes, Your Honor.
You were appointed in 2007 and had been a justice of the Sandigan for several years before that.
Yes, Your Honor.
Okay. How then, however, then as you said, Justice Sereno was the most junior member of the Supreme Court at the time and was only a member of the High Court for only 2 years. That is correct.
Yes, yes,
Okay.
Your Honor.
Now, let me ask this question. How did you feel about the appointment of Justice Sereno at the time? One question. Let me revise that. Were you disappointed?
Point of order. Point of order.
What is the point of order, Your Honor?
Sir, we have here an unprecedented appearance of a
Yes.
justice of the Supreme Court. I enjoin and appeal to everybody to give her the respect owing to the office.
That's precisely I
Now,
gave the
sir,
initial.
you're asking the justice, how did you feel when this is not relevant to the proceedings, sir. Whatever he felt,
It has something to do with the question posed by everyone. Was there bias?
May I answer the question?
I believe she's...
Your Honor, matagal na po akong justice. 20 taon na po. Wala pong karapatan ang isang tao na maging justice kung affected ng emotions. Yaan ho ang isang bagay na hindi ko pinaiiral sa akin. Kasi ho, kung ganyan ako, na puro emosyon at puro feelings, dapat ho umalis ako sa husgado. Kaya ho, itong pag-appoint kay Chief Justice Sereno, ano po magagawa ko? The President appointed her. She was nominated by the JBC. What should I do? Kaya ho, siguro, ang dapat ho, tignan ninyo yung aking mga ginawa kung merong basihan. Pag wala hong basihan, doon ho ninyo sabihin na ito ang aking mga ginagawa ay dahil lang sa aking emotion.
Would it
Yun po
be-
siguro, ay kaya nga ho, ready ako, nandito lahat ng mga dokumento para ipakita at ipaliwanag bakit ko ginawa ang mga ginawa ko. I cannot stand idly by when the power of the Supreme Court, the collegial authority of the Supreme Court under the Constitution is being undermined. And when our decisions reach by the collective wisdom of the justices of the Supreme Court are being set aside or changed, I should speak up. What kind of a justice am I if I just accept what is happening that is not in accordance with the Constitution and the law? So I think what you should do,
You're not.
I think what you should
Please contain your emotions. Sabi nga po ni Justice De Castro, walang place yung emotions dito sa ating ginagawa. Ang hinahanap po natin is the fitness. And I'd like to again point out to Congressman Rocamora, si Justice De Castro is not at issue here dahil siya po ay resource person. The real issue in this impeachment proceeding is the fitness of the Chief Justice to continue holding public office. So if we can just focus on this issue and not divert the issue to anywhere, may mas ma-accomplish po tayo dito sa impeachment proceeding. So
I proceed, Your Honor.
can we please go to another point, Congressman Rocamora?
Just one question on that point. Talking about emotions. Were you emotional? Were you not emotional when
Mr.
you
Chair,
allegedly
Mr. Chair,
panglas
Mr. Chair, I
the
would like
Chief
to be
Justice?
recognized. Mr. Chair.
What is the point of order?
Well, with all due respect again to Congressman Rocamora, there is already the ruling of the chair that we should be relevant to all the questions, especially so that we're dealing with one of the highest officials of the judiciary. In fact, for all we know, since the very beginning, the good justice has been referring to documents and other evidences. So may I just request again at this juncture, Mr. Chair, considering there was already a ruling of the chair and as observed by the majority leader, may we advise our equally good and a good friend, Congressman Rocamora, to please refrain from addressing such bias or insinuation as to bias and some other matters of emotion which are not actually relevant to this proceeding, Mr. Chair.
Point of
Thank you.
order.
Thank you.
What rule
Thank you.
did I violate here?
Thank you.
I'd like to
What rule is violated here?
Point of order.
Well, Mr. Chair, if well, of course,
I-
all
I
of us are
rephrase,
here, but then
Mr. Chair.
if we are being questioned as to the matter being violated, it's the right of the witness, of course, to be accorded the due respect. And in fact, yesterday it was the ruling again of the chair that all of us are reminded that if ever, we should be actually thankful to the Supreme Court for giving us this priority and the respect accorded to the House of Representatives because they are cooperative with this proceeding as we perform our constitutional mandate.
Okay, Your Honor.
And then, yes, if there is a particular provision under the internal rules, especially the impeachment rules of the House of Congress, may we refer to, for point of information of our good Congressman Rocamora, under Section 7, the House may, upon proper petition, provide adequate protection to a complainant or witness if it's shown that is in jeopardy of still participating in this impeachment proceeding.
Mr. Chair, another point of information.
Okay, the chair will make a ruling.
Before that, Mr. Chief,
There is a point of order, and the chair needs to rule thereon. If you have another point of order, you raise it at the proper time. But in the meanwhile, Section 128 of the rules of the House sets the standard set for questions. And the question shall be based on facts and as to obtain information or press for action. No question shall be A, argumentative, B, suggests its own answer. J, repeat a question previously asked and answered. And therefore, these matters have already been asked and answered, and this somehow the questions are argumentative and does not call for facts. So the point of order is well taken.
Another.
Thank you, Mr. Chair.
Besides,
Thank you, Your
the chair notes that you have consumed 16 minutes already as part of your clarificatory questioning, and so we have allotted 5 minutes, but we have given you the leeway and the liberality to ask questions. And so the chair rules that you have exceeded your time, and so we will go to another interpellator.
Just point of information.
And I will now recognize Congressman Gwen Garcia.
Mr. Chair.
Point of information.
Thank you, Mr. Chair.
Mr.
I
Chair.
think I
For
have
that,
been
what is the
recognized.
point of information?
May we just inform the committee that the rule alluded to by the, depended upon by the chair, refers to question hour, not during the impeachment.
Mr.
That is
Chair,
all. That's
may
all.
I raise a point of information?
Okay, please.
We have adopted the rules of court, particularly the rules of criminal procedure and the rules of evidence. Let me read Rule 132, Section 3 of the Rules of Court. Rights and obligations of a witness. A witness must answer questions, although his answer may tend to establish a claim against him. However, it is the right of a witness, number one, to be protected from irrelevant, improper, or insulting questions and from harsh or insulting demeanor. And number three, not to be examined except only as to matters pertinent to the issue. The questions asked by Honorable Racomero are already irrelevant, apart from the fact that they have been insulting Mr. Chair. May I ask that they be stricken off the record?
Okay,
Mr. Chair.
the chair has already ruled on the matter, and as pointed out on a point of information, the rules of criminal procedure and of rules of evidence, rules of court are supplementary to the rules of